This is Consumer Friend.
Hello everyone and welcome back to the Consumer Friend podcast. In today's pod we are going to talk about the exciting subject, of unfair contract terms. Stick with me people. We're going to try and make this as interesting as we can, and we're going to talk about why it is so important to give just a little bit of consideration into the purchase or the contract you are going to make. With me, fresh from her starring role in the House of Commons last week. Was it the House of Commons?
Yeah, it was.
Explaining to the government what fraud and scams are and why it needs to be taken seriously. The person that's so small she calls miniature golf just golf. It's little Louise Baxter. Hi Lou, how are you?
Hi Adam, I am fine, thank you very much.
So you went up to the Big Smoke and spoke to the government about
scams and fraud
scams.
victims, and trying to make sure that we treat victims of scams and fraud the way that we should, which is the same as victims of other crimes, but with empathy and without the blame and shame that's attached to it.
And how was it?
I was quite nervous, to be honest, but it was good, actually. I think that my legs didn't touch the floor on the big chairs, which was a bit annoying. No, it's good fun. It was good because I think it's really important. It's really important messages about the fact that we need to ensure that people understand how serious a crime is, because it's not just about people losing money. It's about people's well-being effects it has on people, and actually highlighting how we need to be better in supporting those victims, because in my opinion we are failing them.
Yes, this is our day job on 5 days a week, not our Consumer Friend job. So we're going to talk about Consumer Friend job, but well done. Very proud of you, Louise, for being in London talking to very important people. Well done.
Wow. It was good. It was good fun. And then I did the telly box this week, didn't I? On the beach.
I was going to say, I also turned on Southeast Today yesterday on the telly, and you popped up on my screen. What's going on? You're having a bit of a moment of fame.
Did you like my Christmas coat? My red Christmas coat.
Red Christmas coat, red glasses.
Red glasses, red fingernails. Red fingernails.
Who's that elf?
I've actually got my elf ears on today as well for you, Adam, just for you.
Anyway, well done, Louise. Really, really, really super proud of you. You're going to make waves in the world, which is more than can be said for
more waves. No, not necessarily. We all just got to do a little bit, haven't we?
We all do. Right. Okay. We are talking about a pure consumer friend topic here. We are talking about unfair contract terms. Now, this is the podcast we promised you lovely listeners last season, but we refused to do it because we couldn't make it as fun as we're going to make it today. So we are going to talk to you about unfair contract terms. Now, Louise, what is your understanding, which I'm assuming is vast, on unfair contract terms?
This is something that, again, I don't do it daily anymore. I used to do it daily, but if we go back before you get to unfair contract terms, there has to be a contract. So if you're going to sort of define what a contract is,
okay,
it's an agreement between two parties where there's an offer, an acceptance of that offer, some consideration, which is something of value. It doesn't have to be money, something of value. There has to be an intention to create a legal relationship, and the people that are contracting have to have what's called legal capacity. So that basically means, to summarise, not too young and not drunk. So,
what? Hang on. Sorry, what?
Not too young. Not
young?
Mentally incapacitated.
Okay.
Yeah, so not mentally incapacitated. So no mental health issues. That means they haven't got mental capacity. We're not going to go into that today. Not too young, because children can't contract unless it's for necessary items. That obviously has changed because of the world we live in. What a necessary item now is not what a necessary item was 10 years ago. So a mobile phone might be considered a necessary item for a 10-year-old now. And drunk people, because you don't have capacity, because you make daft decisions when you're drunk. So That's basically, so if there's a contract in place, there are then certain.
Louise, you don't have to just take the whole podcast. I've got bits that I want to talk about as well. So, I mean, if you want to just take.
Question.
Yeah, you've basically defined a contract as a agreement between a business and a consumer, whether that's written or not, or
Well, no,
already
that's not what a
agreed,
contract is. A contract could be between anybody, but I haven't got to that bit yet. You're not the only one that's done some prep, Adam Carter. I've got giant post-it notes here. Giant. They're bigger than my head, these post-it notes. Right, basically, so if there's a contract, then there are certain terms of a contract. And you asked me, back to my question, don't go to sleep, is what is an unfair contract term? And what is my idea of what an unfair contract term is? My idea of an unfair contract term is a term or a notice that is unfair or unfair to the consumer, basically. Gives the business...
It's weighted in favour of the person making the contract.
When you're talking about unfair terms, it only applies to consumer and business contracts. It's not consumer to consumer or business to business. Unfair contract terms regulations apply to consumer and businesses.
So it doesn't apply on Facebook Marketplace. It doesn't apply to businesses selling to other businesses.
It does. Well, the Unfair Contract Terms Act applies to businesses to business, but we're not going to talk about that because it's complicated. Let's talk about consumer to business purchases.
Okay, I've got a definition of what a consumer is here, which makes me laugh and fall asleep all at the same time. A consumer is defined in the Act. Now, in the Act, we refer to the what's the Act that we always talk about? Consumer Rights Act, 2015.
Easy for you to remember, Adam.
I've gone through so many different acts. A consumer is defined in the Act as an individual that is a natural person rather than a legal entity, such as a company. So the person's got to be a natural person. Wow.
Okay.
Who is acting for purposes wholly or mainly outside his or her trade, business, craft, or profession. So it's someone that's buying something that they don't normally buy. Is that how that works?
No, it's someone that's not buying something for their business.
Oh, okay. In cases of doubt, an individual is presumed to be a consumer until shown not to be.
It's like, for example, so you talk about marketplace. No, you're not. You talk about marketplace, for example, okay, as well. So if a business is selling things, what happens if, as a consumer, you go on and you buy things and then you upsell them? So I go on, I'm going to go, right, I'm going to buy that and I'm going to upsell it for more. When do I become a business? When I do that twice? When I do that 3 times? When I do that 4 times? When is that a business? Because I'm making money from it. So potentially I could be seen as a trader then. That's when the law switches. Okay. See what I'm saying?
I see exactly what you're saying. Who enforces this?
What, the Consumer Rights Act for unfair contract terms?
Yes.
Trading standards. Well, the CMA provide guidance on it, and they can do bigger cases, but the Competitions and Markets Authority, but it's a trading standards local issue. But again, it's one of these things where trading standards have gazillions of pieces of legislation to enforce. So how much is there's not resource in local authorities for them to go trawling websites to check that all terms and conditions are fair. If it comes to their attention, I think they advise.
Okay, Louise. So define the difference between a term and a notice.
Well, a notice is something in a car park. So, for example,
just a car park?
Well, no. I'm trying to give you a practical example. So, if there's a notice up in a car park or in a shop or in a swimming pool, saying, for example, if you leave your personal goods unattended, we can't be responsible if they get taken. So that would be a notice. Or in a car park saying you leave your car parked here at its own risk. We're not responsible for your car getting broken into.
But those notices and those terms, they can't be worded in such a way that are unfair and they have to be transparent. They have to be easy to understand. Not
the notices, the terms, right? So you're getting in relation to notices. There's a couple of things. So let's go with a car park, for example.
Okay.
If you were going into a car park and there was a sign outside the car park barrier that says, we are not responsible for any personal injury or death that happens in this car park, right? That doesn't stand. That's not allowed because you can't exclude personal injury or death. You can't say you're not responsible for it because what if the car park owners decided to have an unauthorised party and everybody died?
So that is something that's that's on the blacklist. Is that right?
That's like an exclusion. That's a blacklist exclusion because you can never, and there's a grey list as well, which makes it really helpful.
Yeah, there is a grey list.
Yeah, you can never exclude liability for death or personal injury. Right, notices are also a bit tricky because again, if the sign saying, so let's go with a sign that's legal, which is the car park owners are not responsible for the loss of personal belongings in this car park. Okay, so that one could
which you see everywhere.
Right, yep. However, if you pay your money, go through the barrier, and that sign isn't till floor 5, you've already made your contract because they've offered you they've given you an offer, which is it's 50p. You've accepted that offer. You've paid your 50p. You've got capacity because you're not drunk, and there's an intention to create a legally binding relationship.
You better not be drunk if you're driving.
That's what I'm saying. So your intention, and I'm not too young because I'm driving. There's no intention to create. There's an intention to create a legally binding relationship. Contract is formed when I go through the barrier. So therefore, they're then trying to put in an additional term, contract term or notice, after I've already made my contract. So they have to come before. They can come again. They have to come before you make the contract, because otherwise you're bound by a term that you never agreed to.
Can we move on to fairness? A term may not be assessed for fairness to the extent that it specifies the main subject matter of the contract, or the assessment would be of the adequacy of the price as compared to what is supplied. This is my problem.
No, that's not.
You've
gone too far ahead. No, you've gone far ahead. That's in relation to. So basically, what the law says is that contract terms cannot be weighted too much in the trader's favour, so in the business's favour, right? So and they can't be contrary to the requirements of good faith, right? So there's some things that come under that, which means they have to be fair, they have to be transparent, but the regulations and the legislation in relation to unfair terms does not apply to things that are specific to the price or that contract, because I can't go if the term in our contract. So me and you've got a contract, and you're selling me a Skoda for £45,000, but a term of the contract is I'll pay you £45,000. I can't claim that term is unfair. The legislation talks about standardised terms. It's essentially, it's a bit more complicated than that, but from a consumer perspective, you're a business, you issue the same terms to everybody no matter what. Those are the terms that potentially could be unfair depending on what you've written in them.
Okay, lovely, thank you. What about plain English then?
Right, so there's right, like you've covered off, there is a blacklist of terms that are not allowed. So there's specific things that aren't allowed at all. And then there is a grey list of things that could be deemed to be unfair. And that's when they're tested for fairness and whether or not they're disproportionately in favour of the business compared to the consumer. And I'll give you an example of that, which could be something like you have an arrangement with a business, and in the contract terms, it says this business can cancel the contract at any time, giving no reason, given no notice. They can just cancel the contract. Let's say it's for window cleaning. Let's just go with window cleaning, right? So at any point, that business can go, right, do you know what? Doesn't matter that you've paid in advance for a year. I'm going to cancel the contract at any time. But that contract doesn't allow the consumer to exercise the same right. So that contract doesn't give that consumer any right to cancel without paying a fee to cancel, for example. So that would be something that would be unfair because that's disproportionately weighted in the business's favour.
Okay, fine. But to counter your example there, what the business can do is it can transfer that service to another business, providing they give the same service.
Well, no, they don't have to because they're cancelling the contract. You don't have to agree with the other one. You can cancel it as a consumer. You don't have to go with the next business they're suggesting. No,
absolutely. But the business can transfer that over to a third party.
Well, but the consumers don't have to go with them.
No.
There's terms that aren't allowed. So, as I've covered up, right, no death or personal injury. Can't exclude an existing consumer right. So your contracts can't take away what the law gives you. So your contract can't give you less rights than what you've got in law. They can't take away. So, for example, goods have to be satisfactory quality, fit for purpose and as described. You can't have a contract term that says we're just not going to be liable for any faulty goods because that takes away your legal statutory rights. You also can't do things like exclude for compensation for delay or exclude for damages for delay. You can't do that as a business. So there are things that are banned that you just can't do. And there's a list of these. There's a black list of these, and we're going to be up on the website, so that's going to be fine. People can have a look at those. But then there are other things, things like management reserves the rights to suspend services without liability. Can't do that either. You can't just go, I'm not delivering your contract anymore. Tough. It was in my terms and conditions, because that's not allowed. But there are sort of grey list things where that's where the fairness test will apply, and then the transparency test will apply. Like, so if a consumer's been tied in for too long to a contract, for consumers losing prepayments for whatever reason, those terms are grey because it depends on the nature of the contract, and then you would apply whether it's fair. And if it is fair, then you would move on to, was it transparent? And by transparent, no jargon, it's something called, it's the red hand rule. Is it highlighted with a big red finger? Have you got a big foam finger out to highlight it, to say, have you seen this? Are you happy to sign up to it?
Okay, so just sticking back with the grey list. Types of terms in the grey list overlap with each other, but may cause or allow one or more of the following common problems. So, consumer being denied full redress if things go wrong. Yep. Consumers being tied into the contract beyond they would normally expect. The business not having to perform its obligations, as you said. Consumers unreasonably losing prepayments if the contract is ended, so if they've paid up front. The business arbitrarily varying terms after they've been agreed, so changing the contract. The business determining the price or subject matter of the contract after the consumer has become bound by it, entering the car park before they see the sign.
And you don't use words like arbitrarily.
Yeah, but that's what it says in the guidance.
Verbose to you, Adam Carter. That's a word we both had to Google this week.
Yes, we did. And consumers being subject to disproportionate financial sanctions. But we'll come on to a bit about that in a minute. But you mentioned the word transparency towards the end there. So define what transparency is.
Right. So the words are generally the way that these legislation should be interpreted is that the words will be if the words are complicated or they've got a double meaning, for example, those words will be interpreted in favour of the consumer. Okay, but what they look for in an unfair term is jargon, so using big words with an intention to mislead people, that you haven't written in clear sentences, reader friendly. If it's too small, I like on really like size 8 font in a grey colour, so you can't really read it properly. Yeah. And what have I actually? I can't even read my own writing there. Oh, and so they've got to be small words, so easy words like we talk about, plain English,
comprehensible.
Reading age of a 9 to 12-year-old. Write it for a 9 to 12-year-old. And informative. So not loads of words that people don't understand, and then a term hidden in the language, which we often see, especially from a legal drafting perspective. There's still a load of Latin within law. Yeah. Right? So again, we write in really big words and big sentences and complex language. And when you're talking about terms for consumers, I mean, we'll cover it off, but who actually reads the terms, which is why we're saying to people they should read the terms, and businesses need to be educated on how to draft them plainly, and we can help with that. We can all support with this stuff around plain English and drafting the terms for businesses in relation to this, because it shouldn't be so complicated.
It really shouldn't. So when drafting contracts, it is important to consider how consumers actually behave in practice. Yeah. So that's what needs to be considered so we talk about this all the time. This is inclusive design, right? This is making sure that anyone can access your services by them being able to understand what your service is.
Yeah. But also it shouldn't be disproportionately favoured in your favour as a business, so that you can cancel or hold on. Like deposits are a big one. So contract terms from a deposit perspective. So you have a contract. Let's go. You've got let's go for weddings. Weddings, I've dealt with a lot of complaints around weddings and unfair terms in wedding contracts. So your wedding costs, I'm going to go with a round number because you know that quick maths is not my thing. So like £10,000. My wedding is going to cost £10,000. I'm not getting married again, just to be clear, but my wedding is £10,000. My deposit for my wedding is £2,000. Okay. Now in my contract terms, it says if I cancel this contract at any time, I lose my £2,000. Now that could be deemed to be unfair, because if I book my wedding today now, and then I cancel my wedding tomorrow, it hasn't cost that wedding venue £2,000.
No.
So it's disproportionate. It should be based on the actual cost to that person and to that organisation. So if actually their argument was, but you've booked your wedding for next Saturday, we're not going to be able to rebook that venue out again on that Saturday, then I might lose my £2,000. But it has to, if it's 4 years' time, they're surely going to be able to find somebody else to take that wedding date. So it has to be proportionate. It can't just be outrageous and all weighted towards the business.
So, sorry, when are you getting married?
Oh, never.
Okay, so what about paying for the whole service up front?
Well, so what sort of service are we talking about?
So let's say the typical one is a builder. So a builder comes around and goes, I'm going to do your roof for you. It's going to cost you £15,000. I want all the money up front.
Have you not been here on the other podcast where we would categorically tell people not to pay up front?
but I didn't listen to the other podcast. I was just recording it.
We would categorically tell people not to pay up front.
Of course we would.
Right, so what? And then, so where's the term? What does it say in the terms and conditions?
It was an oral contract. Quote was sent.
Well, it's not. Let's not go with an oral contract. It's not an oral. You can't go oral contract like that. It has to be written.
What can the terms be then? I just found a massive hole in my trousers.
It's the same example. Wow. Adam's just shown me a hole in his trousers, which is just amazing. Right, your ADHD is off today. If you right, so no, but it's the same as a wedding case study. It's a deposit argument, isn't it?
Okay.
I think
Shall I say what I've got written down?
Yeah.
Consumers sometimes make prepayments in advance of receiving products or services, a term that makes any substantial prepayment entirely non-refundable, whatever the circumstances, potentially allows the trader to make an unjustified windfall gain. This is especially true where there is no fault on the part of the consumer and the contract is ended by the business.
Right, okay, so if we consider, we just go back to my previous example, which I'm not obviously my examples normally involve you buying a horse, so this is positive, or a squirrel. Haven't mentioned squirrels, and I haven't moaned about buying the Tombola prizes for the Wear a Christmas Jumper Day tomorrow yet either. If you go back to the wedding, if a term in that contract also said, like, so if the business cancels for whatever reason, they get to keep the consumer's deposit as well. So say, let's flip that on in the reverse. I book my wedding today. Business turns around to me tomorrow and goes, we're cancelling that. But they're allowed to hold on to my deposit. That's an unfair term.
Yeah.
Because there's a significant imbalance again. So if I cancel, I lose £2,000. But if you cancel, I lose £2,000 as well. It's weighted towards the business.
It's not fair. Who decides it's not fair? Well,
it's all subjective. So ultimately, it would be a court. So if you challenged it, I mean, you could go to trading standards. They could provide advice, and they will to businesses and say, look, we think these terms are unfair. Also, organisations like Trustmark or Buy with Confidence will provide you with terms and conditions and advice on your terms and conditions. You can also get some from C2 Compliance does a lot of work in relation to terms and conditions as well. So you can get standardised ones which are standard and fair. You'll know they're fair because you've bought them in relation to them being fair. But it would be subjective. So when I used to do this, I would go through each one and I would give advice and I'd go, this one's unfair, redraft this one, boom, boom, boom. If that business went no, then the local authority has to take civil action or civil action against them to say, look, you need to change that. And ultimately, they then decide whether they're going to do that. But if it's a consumer challenging a business's terms and conditions because they've not got their deposit, say, I haven't got my money back for my wedding, so I'm now going to go to the wedding venue and go, give me my money. They go, no. Ultimately, I've got to go via alternative dispute if there is one, if they're a member of a redress scheme that I can get money back from, an ombudsman, for example, or I've got to go to court.
Okay. All those sound like a lot of hassle.
Yes, they are a lot of hassle, which is why we would always say pay with a credit card.
Businesses are not allowed to punish a consumer unfairly for breaching the contract. So if I've got a contract with a TV company and I say I want to cancel my contract with you, and they've said, well, you've got 6 months left, but if you want to cancel it now, you've got to pay us 12 months worth of subscription. That's unfair, right?
Yes. Yep.
So that's what that is.
They can't disproportionately charge you for it. They can charge you for it. Again, if a consumer is in breach of contract or you're in breach of contract, they can hold you to the contract amount. So they could hold you to the 6 months. They can't hold you to 12 and a cancellation fee. That would be unreasonable. They have to be what it's going to cost them as well. It's all, this is the problem. It's all subjective, Adam. This is the whole problem with it, because it's also, if you're going to challenge this, it's down to a judge on the day on whether or not they think a particular term is unfair. There's guidance on this which we can look at, but it's subjective. It's basic. Like, what would you think is fair? It's what the average consumer would deem it. So think about average people, what they would deem to be fair.
Okay, I think I've got some words about an average consumer coming up. But next one is around that cooling off period. Okay, Lou, what about a cooling off period? What about if you decide to cancel within a set cooling off period if they do get one?
Right. So so the question you're asked. So cooling off periods, they can't be taken away in contract terms.
Okay.
Because it's your statutory right. So like I said, you can't have less rights than you would have in the eyes of the law. Mm-hmm. So if the law says, if you buy something online, you get a 14-day cancellation period. Yeah. Let's just go with that as a general. I'm not going to go into details of all of the if, buts and maybes. Your contract can't go, but with us, you don't get a 14-day cancellation period. That would be an unfair term.
Great news.
But this is the problem. The problem with a lot of this stuff is, again, it doesn't go in a business's favour if the terms and conditions are too long. Because, again, consumers don't generally read terms and conditions. And this is a problem. They don't read it. So this is what I was saying to you earlier, wasn't it, when we were looking at that, around the the contract terms companies are put into contracts to see whether people actually read the contract terms.
So this is agreeing to terms and conditions.
Yeah, so when I had a little Google around this, there was a Wi-Fi provider that inserted a clause into its terms and conditions stating that users agreed to clean public toilets, including toilets at festivals, as part of using their service. It was a joke, but nobody read it. So people just agreed and clicked the terms and conditions.
Yeah.
So people just clicking through. A game retailer inserted a clause into their terms and conditions stating that users agreed to give up their firstborn child as payment for the software. And again, people were just agreeing to it because they don't read the terms and conditions.
And now, but then from what we've discussed already in the last however long it's been, is that surely would go onto the blacklist.
What? Selling your firstborn child?
Yeah, of course.
Software.
Of course.
But again, I'm not being funny. If you're in a position where you've read the terms and conditions and you're thinking, right, I'm going to make a contract here, you wouldn't go, oh, do you know what? I'm going to agree to this contract and then I'm going to argue whether or not I think it's on the blacklist or not. People don't read.
I'm going to argue. What if the court decides that you do have to sell your firstborn?
Yeah, there's other ones around people giving up their immortal soul to the company. There's other ones that talk about charge £5 for calling customer service and asking a representative to read out the terms and conditions whilst not. So a mobile phone provider included a clause in its contract that they would be charged for £5 if they ask customer service to read out the terms and conditions. And again, because customers aren't reading the fine print. And then you've got things around sponsorship. Lots of companies have put these into their terms to test whether or not consumers read the terms. And
but we already know. We already know that we don't. So
we get a problem though. We get
exactly right, of course, and we get that problem, and then there's all these hassles and all these nightmares that you have to do. And then you have to start understanding about unfair contract terms. You then have to start understanding about your rights under the Consumer Rights Act and all this kind of thing.
Well, that's what we're here for.
Why can't it be that businesses just act nicely? All businesses.
But this is about education again. So, like, some businesses they're just people. So, and they might be acting nicely, but they just don't know what the law says. Again, if I didn't know this stuff, you would write your contract so they were in your favour. Because how, as a business, are you supposed to know about all the different pieces of legislation that you're supposed to comply with? You're not. It's impossible. So businesses need support and. From us, from anyone, from trading standards, anyhow, from people to explain this to them. But again, if a business, it's too complicated sometimes. If a business understands what a consumer is entitled to, they will get it right. We don't need to overcomplicate business advice and information either.
I've got an interesting one here where some contracts write in only written terms will be honoured or employees can't make statements that don't match this contract. So people could be entering into a contract that they've based on what a salesperson has said. And that salesperson has said, oh, it does 200 miles to the gallon. And actually on paper, it says it only does 50 miles to the gallon. But the consumers bought the car based on it's doing 200 miles to the gallon. That's a breach of contract, right?
Oh, no, it's not a breach of contract. No, it's it's a criminal offence for starters.
It's fraud. It's
Fraud.
fraud. It's good.
Fraud.
It's out and out fraud.
Fraud
Okay,
or consumer protection offence.
What example am I trying to
Right,
find?
so anything that's said, if people are, Adam, I'm slightly concerned that your day job is very, very focused on fraud, and you just, right, there may be some training, maybe some additional training.
I didn't have an example on that. I made one up on the spot, and I realised I got it wrong instantly.
Right, so anything said by a representative of company will form part of your contract. So, but that's slightly different. That wouldn't come under unfair terms. That would come as that you've been misled. So it's either misrepresentation or breach of contract. So it's either as described or misrepresentation from a civil perspective, from a contract law perspective. I mean, all jokes aside, it is breach of contract. If you describe something that isn't as it is, it's a breach of contract. Also,
I've gone a bit too serious.
Just to be clear, just also fraud.
Changing the contract during the term of the contract.
Well, you can do that as long as you have agreement from the parties. So, yeah, if you want to change it up, you just have to have agreement. If you can't, you're breaching it. It's a breach.
So usually it'd just be minor changes.
Yeah, and normally we just all agree to those things, don't we? Again, because we don't read the terms and conditions. Because it's too complicated and there's a lot of legal jargon in them. You almost there needs to be like a summary, easy read. You know, like now they do it with credit agreements as well, like the key bits of information. And you have like a front sheet that makes it easier to understand.
We are going to attempt to put a summary, easy read, unfair contract terms trained into on the website, and that should be up and running when this podcast is launched, shouldn't it, Louise?
Well,
I'm writing it.
I was a little bit worried. I'm a little bit worried about you. No, Adam, you wanted it. It's a challenge.
I am definitely writing it. I am a lot more educated after this half an hour of talking to you.
Well, I also think as well, that's like a little game we could play now, like Challenge Adam. So if people have got any legal questions or any like legal things they need the answers on, it's a challenge to Adam, and he can then go and find out and research the answers, and then I can go, no, you've got that wrong on a podcast.
Yes. And you know that's going to happen.
Or just pretend he's got it wrong right till the end and then go, actually, you got it right.
Oh dear, oh dear. All right. Let's all take the mickey out of Adam.
One of my ears
again.
Adam, one of my elf ears has just fallen off. This is upsetting.
I think we've done unfair contract terms, Louise.
The only thing that
in quite a messy way.
It's going to be an interesting one to edit. The only thing that I would say in relation to summarising in relation to terms and conditions, if you're concerned that you're being held to a term that you think is unfair, ping us an email and we can see what we'll give you our opinion or our limited opinion on it. But if it's something serious and something that's going to cost you great inconvenience or some financial losses, or it has to be prominent. So firstly, you have to have been told about it for it not to be unfair. And also just remember that it has to be equally weighted. I always think about it as like weighing scales. The contract has to be equal in weighing scales, like old school ones, which you put like weights on the top and flowering, just to ensure. And if it's too weighted in front of the trade, to challenge it. There will be times, and I won't lie, I have challenged terms before, and they people ignore you. However, you can continue to challenge and see what that situation is. It's an education piece, this one.
Okay, Louise, we're done. There will be
just one thing we didn't actually cover, which is really quite important. If a term is deemed to be unfair, it's not legally binding on you. So if you do challenge a term,
I suppose we're assumed knowledge here, aren't we? That's what we've entered into.
So, but that's a reason you challenge, not just go, that's unfair, that's outrageous. It's about because it's not legally binding. But the other thing about that is if the rest of the contract can still be read like in its entirety, and that term can be removed, and the rest of the contract still makes sense, the rest of the contract will still stand. However, if the terms are unfair, that are not legally binding, are removed, the whole contract could fall down.
Okay.
Because it might not make sense without those unfair terms.
Yeah, because it might be based on that
particular
unfair term. Yeah. That makes sense.
Unfairness.
It comes under unfairness. Okay, lovely. Louise, thank you very much. So basically, all contracts should be jargon-free. Unambiguous.
That's got to stay in.
Yeah, it will. Clear and not open to misinterpretation. Reader friendly, legible, comprehensible, informative. Louise, thank you very much. The information will be on the website.
Also, on the website, there's a new blog post around how to buy safely before Christmas, how not to buy counterfeit goods, fake goods. Also, some information on buying second-hand cars and if something goes wrong, which is coming in your direction. Adam was supposed to upload those many moons ago. I don't know why I bother, to be honest. I just don't know why I bother writing things if you're not going to put them on the website. Just, what's the point?
I think they were on the website, but they weren't on there after we had the new website put on. I think they were there.
I don't think they were.
You might be right as well, to be fair. All right. Thank you very much, everyone. We are available on consumerfriend.org.uk. Please like, subscribe, listen, rate, review, all that kind of stuff. Any questions, please email us, info@consumerfriend.org.uk. Louise, thank you very much for taking us through the world of unfair contract terms. It was a roller coaster of emotion.
I've got to go and get ready for the elves arriving tomorrow now.
Thank you very much, Louise. Goodbye.
This is Consumer Friend.